Please be seated. The sitting is open. The court meets today and will meet in the coming days to hear the oral arguments of the parties on the preliminary objections raised by the respondent in the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan. This morning, the court will hear the first round of oral argument of the Republic of Azerbaijan. I recall that since the court included upon the bench no judge of the nationality of either party, each party proceeded to exercise the right conferred upon it by Article 31 of the statute to choose a judge ad hoc to sit in the case. The Republic of Armenia chose Professor Yves Daudet, and the Republic of Azerbaijan initially chose Judge Kenneth Keith, both of whom were duly installed as judges ad hoc on the 14th of October 2021 during the phase of the present case that was devoted to a request for the indication of provisional measures submitted by Armenia. Following Judge Keith's resignation on the 21st of April 2023, Azerbaijan chose Judge Koroma, who was duly installed as judge ad hoc on the 20th of June 2023. I shall now recall the principal steps of the procedure in the present case. On the 16th of September 2021, Armenia filed in the registry of the court an application instituting proceedings against Azerbaijan concerning alleged violations of the International Convention on the Elimination of all forms of racial discrimination. I shall now refer to this convention as CERD. To found the jurisdiction of the court, Armenia invokes Article 36, paragraph 1 of the statute of the court and Article 22 of CERD. The application also contained a request for the indication of provisional measures pursuant to Article 41 of the statute and Articles 73, 74, and 75 of the Rules of Court. By an order of the 7th of December 2021, the court, having heard the parties, indicated certain provisional measures. By an order dated 21st of January 2022, the court fixed 23rd of January 2023 and 23rd of January 2024 as the respective time limits for the filing of a memorial by Armenia and a counter-memorial by Azerbaijan. The memorial was filed within the time limit thus prescribed. By a letter dated 16th of September 2022, Armenia, referring to Article 76 of the Rules of Court, requested the modification of the first provisional measure set out in the court's order of the 7th of December 2021. By an order dated 12th of October 2022, the court found that the circumstances as they then presented themselves to the court were not such as to require the exercise of its power to modify the measures indicated in the order of the 7th of December 2021. By a letter dated 28th of December 2022, Armenia, referring to Article 41 of the statute and Article 73 of the Rules of Court, filed a new request for the indication of provisional measures. And by a letter dated 26th of January 2023, it communicated to the court the text of a further provisional measure sought. By an order of the 22nd of February 2023, the court, having heard the parties, indicated a provisional measure. On the 21st of April 2023, within the time limit prescribed by Article 79 bis, paragraph 1 of the Rules of Court, Azerbaijan raised preliminary objections to the jurisdiction of the court and the admissibility of certain claims contained in the application. Consequently, by an order of the 25th of April 2023, the Court, noting that, by virtue of Article 79 bis, paragraph 3 of the Rules of Court, the proceedings on the merits were suspended, and taking account of Practice Direction 5, fixed 21st of August 2023 as the time limit within which Armenia could present a written statement of its observations and submissions on the preliminary objections raised by Azerbaijan. The written statement was filed within the time limit thus fixed. By a letter dated 12th of May 2023, Armenia, referring to Article 76 of the Rules of Court, requested the modification of the Court's order of 22nd of February 2023. By an order dated 6th of July 2023, the Court found that the circumstances, as they then presented themselves to the Court, were not such as to require the exercise of its power to modify the measures indicated in the order of the 22nd of February 2023, indicating a provisional measure. On the 28th of September 2023, Armenia, referring to Article 41 of the statute and to Article 73 of the Rules of Court, submitted a new request for the indication of provisional measures. By an order dated 17th of November 2023, the Court, having heard the parties, indicated certain provisional measures and directed the Republic of Azerbaijan to submit a report to the Court on the steps taken to give effect to the provisional measures indicated within 8 weeks as from the date of the order. Azerbaijan accordingly submitted a report on the steps taken to give effect to that order on 12th of January 2024. Armenia provided comments on that report on the 26th of January 2024 within the time limit fixed for that purpose. By a letter dated 4th of March 2024, Azerbaijan reacted to those comments. After ascertaining the views of the parties, the Court decided, pursuant to Article 53, paragraph 2 of its rules, that copies of the preliminary objections of Azerbaijan and the written statement of Armenia on those objections, as redacted by the parties in order to protect personal or sensitive information, would be made accessible to the public on the opening of the oral proceedings. I would now like to welcome the delegations of the parties. I note the presence of the two agents, accompanied by members of their respective states' delegation. In accordance with the arrangements for the organization of the proceedings, which have been decided by the Court, the hearings will comprise a first and a second round of oral argument by the parties. The first round of oral argument will begin with the presentation of Azerbaijan today from 10 a.m. to 1 p.m. Tomorrow, Tuesday, 16th of April, Armenia will present its first round of oral argument from 10 a.m. to 1 p.m. The second round of oral argument of Azerbaijan will take place on Wednesday, 17th of April from 4:30 p.m. to 6 p.m. and Armenia will present its second round of oral argument on Friday, 19th of April from 10 a.m. to 11:30 a.m. In this first sitting, Azerbaijan may, if required, avail itself of a short extension beyond 1 p.m. in view of the time taken up by my introductory remarks.
You have the floor, Excellency.
Merci bien, Monsieur le Président, Mr. President, members of the Court. It is an honor to appear before you again and to do so on behalf of my country, the Republic of Azerbaijan. Azerbaijan considers its preliminary objections in this case imperative for the proper administration of international justice. Armenia's application misuses the third and tries to escape its obligation to attempt settlement of its dispute with Azerbaijan by way of negotiation before invoking the court's jurisdiction. This is the preliminary objections hearing in the first of two cert cases between Azerbaijan and Armenia. However, when analyzed carefully, it is clear that the two cases are very different. Azerbaijan's third complaint, which will be the focus of next week, goes to the very heart of the Convention. It is centered upon ethnic cleansing and related systematic cultural erasure by Armenia of the Azerbaijani population and culture in the formerly occupied territories of Azerbaijan. These Azerbaijani territories were illegally invaded between 1991 and 1994 and subsequently occupied by Armenia for more than 30 years in breach of multiple resolutions of the United Nations Security Council. That invasion and subsequent occupation were driven by an overtly racist and nationalist ideology known as Tekahron. This racist ideology espouses the notion of a superior Armenian Aryan race, the racial inferiority of Azerbaijanis, and the unification of all ethnic Armenians within a single mono-ethnic Armenian state, extending into the internationally recognized sovereign territories, not only of Azerbaijan, but also of other neighboring states. It was that overtly racist ideology which drove all of the Armenian misconduct that is the subject of Azerbaijan's third complaint. Azerbaijan's third complaint is also procedurally orthodox. It arises out of a timely invocation of the court's jurisdiction under Article 22 of the Convention, following a genuine attempt to negotiate until the other party walked away. By contrast, much of Armenia's third complaint, which is the focus of this week, does not concern the Convention at all. It concerns the military conflicts connected with Armenia's illegal occupation of almost one-fifth of Azerbaijan's land territory from the early 1990s and the subsequent liberation of that territory by Azerbaijani forces. Armenia's third complaint includes allegations of serious mistreatment of Armenians, including Armenian soldiers, POWs, and civilians, in connection with those conflicts. And it includes associated allegations of arbitrary detention and enforced disappearance of Armenians. In short, Armenia's third complaint includes a kaleidoscope of grievances arising in connection with those military conflicts. Such issues do not lend themselves to the court's jurisdiction under the cert. This is Azerbaijan's ratione materiae objection, on which I will elaborate shortly. Additionally, the entirety of Armenia's third complaint suffers from a fatal procedural flaw. Namely, to the extent that its complaint does arise out of a dispute between Armenia and Azerbaijan with respect to the interpretation or application of cert, Armenia's invocation of the court's jurisdiction under Article 22 was premature. That is because Armenia failed to engage in negotiations with Azerbaijan in an attempt to settle that dispute, and failed to pursue as far as possible the limited discussions that did take place. From the outset, Armenia had its sights firmly set on commencing these proceedings before the court and using the fact of these proceedings to wage a public media campaign against Azerbaijan. This is Azerbaijan's objection that Armenia has failed to comply with the negotiation precondition required by Article 22 of CERT, on which I will also elaborate shortly. An overriding explanation for Armenia's broadly framed CERT complaint is the limited scope of the compromissory clause at Article 2 of CERT. Armenia cannot resort to international adjudication with respect to its allegations of international humanitarian law breaches, arbitrary detention, and enforced disappearance. Thus, it has been driven to shoehorn those complaints, which properly analyzed contain no discriminatory elements within its CERT application. This preliminary objection phase provides an opportunity for the court to define parameters for its substantive CERT jurisdiction, both in respect of the military conflicts between Armenia and Azerbaijan, and with respect to other conflicts around the world. This would be especially timely, given the growing tendency to misuse CERT in order to bring within the preview of this court ever more wide-ranging disputes. I will make some further remarks with respect to each of Azerbaijan's preliminary objections before handing over to members of Azerbaijan's council team who will lead you through the details. As I have mentioned, and as elaborated at paragraph 71 of Azerbaijan's preliminary objections, dated 21 April 2023, Azerbaijan raises two preliminary objections with respect to Armenia's CERT complaint. The first is that Armenia's complaint should be dismissed in its entirety due to Armenia's failure to comply with the negotiation precondition at Article 22 of CERT. Azerbaijan views that precondition as a solemn obligation of all CERT parties and as a critical precursor to CERT proceedings before the court. Consequently, Azerbaijan approached the negotiations with respect to Armenia's CERT complaints seriously and with a view to settling the CERT disputes. It is important for the court to appreciate the context here. Prior to Azerbaijan's attempt to negotiate the CERT disputes, Azerbaijani and Armenian representatives had not met for 30 years. As Professor Talman will explain, the exercise of setting even the basic framework for the negotiations to come took many months. There followed just two short online meetings of any substance, lasting a few hours each, before Armenia filed its application at the court. To say the least, this came as a surprise to Azerbaijan. There had been no genuine negotiation process before Armenia filed its complaint. The result is that the legal requirements for the invocation of the court's jurisdiction under Article 22 were not met. Armenia filed its application before even allowing a third meeting to discuss the parties' positions. Having received Azerbaijan's opening positions, Armenia simply broke off the discussions on 15 September 2021 and filed its pre-prepared application the very next day. In Azerbaijan's submission to declare the negotiations precondition in Article 22 met in such circumstances would be to render that precondition devoid of meaning. Azerbaijan requests that the court use this opportunity to emphasize the importance of compliance with applicable negotiation requirements before invoking the court's jurisdiction. Azerbaijan's second preliminary objection is that even if the negotiation precondition is met, several elements of Armenia's application fall beyond the material jurisdiction of the court under Article 22 of CERT, because they are not capable of constituting racial discrimination within the meaning of CERT. Specifically, Armenia's complaints about the alleged murder, torture, and inhumane treatment of Armenians during armed conflict, the alleged arbitrary detention of Armenians, and the alleged enforced disappearance of Armenians all fall beyond the parameters of a CERT complaint. Rather, they engage issues of international humanitarian law and other norms of international human rights law that are clearly not subject to the court's jurisdiction under the CERT. There is one exception. As indicated in my letter to the court of 5 April 2024, in its written observations, Armenia belatedly particularized some of its allegations of mistreatment with respect to Armenian civilians during the armed conflict, with reference to specific evidence purporting to indicate misconduct that is capable of falling within CERT. Now, as a responsible litigant, and in the interest of the court's efficient conduct of this proceeding, Azerbaijan has decided to withdraw its ratione materiae objection with respect to any of those adequately particularized allegations. Mr. Wordsworth will pick up this issue further in his speech today. For now, I would simply note that while it accepts that the court has jurisdiction over those exceptional allegations, Azerbaijan is certain that it will defeat them at any merit stage. In its formal submissions, at page 750 of its memorial, Armenia tries to dress up the relevant elements of its application as CERT complaints by simply adding the adjective discriminatory before each of its allegations, and emphasizing that the allegations concerned ethnic Armenians. You can see it on your screen. But simply adding these words to describe allegations that engage other norms of public international law without any accompanying specific evidence of racial discrimination is not sufficient to make those allegations capable of falling within the CERT. Armenia had to do more. Two further points warrant attention before I hand over to Professor Tolman. First, Azerbaijan's ratione materiae objection concerns only those aspects of Armenia's CERT complaint that fall beyond the subject matter of the Convention. It is not aimed at excluding the entirety of Armenia's CERT complaint from scrutiny by the court at this preliminary stage, at any merit stage, excuse me. Thus, Azerbaijan has raised no objection at this preliminary stage with respect to a number of Armenia's CERT complaints, including those connected with hate speech and alleged failures to take effective measures to combat racial discrimination. What is at stake here is the scope of the court's jurisdiction under Article 22 of CERT. In Azerbaijan's submission, the court can, and if it rejects Azerbaijan's first preliminary objection, then it should, building on the logic of its recent judgments, define the limits of its jurisdiction under the CERT. Second, while they fall beyond the court's substantive jurisdiction under CERT, Azerbaijan does not in any way condone alleged violations of international humanitarian law and other international human rights norms. On the contrary, Azerbaijan takes such allegations very seriously. The record shows that, unlike Armenia, Azerbaijan has not shied from convicting its own nationals of appropriate crimes where the allegations have been proven through judicial process. Of the dozens of Armenian POWs and other detainees taken during the Second Karabakh War and its aftermath, all the POWs and most of the detainees have been repatriated to Armenia. The rest are still incarcerated because they either have been convicted of serious crimes, including mercenarism, torture, and murder, or are currently being prosecuted for war crimes, terrorism, or separatism. In other words, the ongoing detention has nothing to do with racial discrimination. Similarly, Armenia's allegations concerning enforced disappearance of Armenians have nothing to do with racial discrimination. But Azerbaijan takes them seriously and has been working in cooperation with Armenia to ensure clarity, transparency, and mutual trust in the search for missing persons from both sides. Mr. President, members of the Court, that concludes my opening remarks. Azerbaijan's distinguished counsel will now address each of the preliminary objections raised by Azerbaijan. First, Professor Talman will address you on Azerbaijan's objection relating to Armenia's failure to comply with the negotiation requirement under Article 22 of CERT. Second, Mr. Wordsworth will address Azerbaijan's ratione materiae objection, with particular focus on Armenia's complaints about the alleged murder, torture, and inhumane treatment of Armenians during the armed conflict. Third, Professor Boisson de Chazourne will address you on Azerbaijan's ratione materiae objection related to the alleged arbitrary detention and enforced disappearance of Armenians. Thank you, Mr. President, honorable members of the Court, for the privilege of appearing before you. I now kindly ask you, Mr. President, to invite Professor Talman to address the Court.
I thank the agent of Azerbaijan for his statement. I now invite Professor Talman to take the floor. You have the floor, sir.
Monsieur le Président, Madam Vice President, distinguished members of the Court, it is an honor to appear before you. My task today is to present Azerbaijan's first preliminary objection that the application should be dismissed because Armenia failed to comply with the negotiation precondition in Article 22 of CERT. Under Article 22, a dispute may be referred to the Court only if it is not settled by negotiation or by the procedures expressly provided for in this Convention. The two threshold requirements for the Court's jurisdiction, negotiations and Convention procedures, are alternative and not cumulative. Armenia does not contend that its dispute with Azerbaijan was submitted to procedures expressly provided for in the Convention. The crucial question for the Court's jurisdiction, therefore, is whether the dispute is one that is not settled by negotiation. Mr. President, members of the Court, the question of whether the negotiation precondition under Article 22 is fulfilled has not yet been decided. In your order of 7th December 2021 on provisional measures, the Court observed that it appears that the dispute between the parties had not been settled by negotiation. No definite finding was made at the time. At the stage of the proceedings, the Court needed only decide whether prima facie it had jurisdiction. The prima facie threshold is, of course, substantively lower than that which the Court must now apply in order to establish definitely whether or not it has jurisdiction over Armenia's third complaint. Indeed, the Court expressly reaffirmed that its decision in no way prejudges the question of jurisdiction of the Court. The Court may recall that in Georgia versus Russia, it also found at the provisional measure stage that the dispute had not been resolved by negotiation and that prima facie it had jurisdiction. This did not prevent the Court from ruling later at the preliminary objection stage that the parties did not engage in negotiations and that consequently it had no jurisdiction over Georgia's third complaint. The same is true in the present case. Armenia has not fulfilled the negotiation requirement, and there is thus no jurisdiction under Article 22 of CERT. In Georgia versus Russia, the Court set out the conditions that must be fulfilled in order to meet the negotiation requirement in Article 22. First, there must have been negotiations between the parties, or at least a genuine attempt at negotiations by the applicant. Second, if negotiations were conducted or the applicant genuinely attempted to engage in negotiations, the negotiations must have been pursued as far as possible with a view to settling the dispute. Neither of these conditions has been fulfilled by Armenia in the present case. Mr. President, let me start with the first condition. Whether there have been negotiations between the parties, or at least a genuine attempt at negotiations by the applicant. This depends on what constitutes negotiations in terms of Article 22. In determining what constitutes negotiations, the Court observed that, I quote, "Negotiations are distinct from mere protests or disputations. Negotiations entail more than the plain opposition of legal views or interests between the two parties, or the existence of a series of accusations and rebuttals, or even the exchange of claims and directly opposed counterclaims." End of quote. Rather, the concept of negotiations requires that the parties engage in discussions with a view to resolving the dispute, or at least make a genuine attempt to do so. Whether discussions or contacts between the parties constitute negotiations depends upon the substance. The Court held that the subject matter of the discussions or contacts must relate to the substantive obligations under CERT. Compliance with the substantive obligations under CERT must be at the heart of the contacts or discussions for these to qualify as negotiations. It is not sufficient for there to be exchanges between the parties. These exchanges must concern the substantive obligations contained in the CERT, or, in other words, matters concerning the interpretation or application of CERT. This substantive requirement excludes pre-negotiations, negotiations about negotiations, from the concept of negotiations under Article 22. Pre-negotiations are distinct and prior to actual negotiations. They determine the location, procedural modalities, scope, and topics for discussion. Pre-negotiations are not about the substance of the dispute and thus do not qualify as negotiations in terms of Article 22 of CERT. In its Provisional Measures Order of 7th December 2021, the Court noted that the parties engaged in a significant number of written exchanges and meetings over a period of several months. The Court, however, also noted that these exchanges covered the procedural modalities, scope and topics of the negotiations. Such procedural or technical exchanges, according to the Court's own definition, do not qualify as negotiations. Armenia claims that for over 10 months it exchanged more than 40 pieces of correspondence with Azerbaijan and participated in 7 rounds of meetings in an effort to settle the dispute amicably. It further claims that the parties engaged in nearly a year of extensive negotiations. Mr. President, these statements are misleading. They confuse the parties' lengthy pre-negotiations with actual negotiations as required by Article 22. While Armenia meticulously lists every single piece of correspondence between the parties in its memorial, it does not say a single word about the content of these documents. A closer look at the content of these documents and the subject matters discussed at the online meetings between the parties paints a very different picture. Mr. President, members of the Court, let me take you through the exchanges between the parties one by one. The correspondence between the parties started on 22nd November 2020. In a 2-page letter addressed to the Foreign Minister of Azerbaijan, the Minister of Foreign Affairs of Armenia alleged for the first time, in very general terms, that Azerbaijan, over the course of the past decades, had violated its obligations under multiple provisions of the Convention. Armenia also invited Azerbaijan to enter into negotiations for the purpose of addressing and remedying its violations. The letter provided a non-exhaustive list of 8 abstract actions through which the Convention had allegedly been violated, but did not contain any information on specific violations or any request for remedies. Azerbaijan's foreign minister responded on the 8th of December 2020, rejecting Armenia's assertions and listing on his part, by example, 7 general actions by which Armenia had violated its obligations under the third. In that letter, Azerbaijan also indicated that it remained open to negotiating this matter with Azerbaijan. The 2 letters did not address any specific violations of the Convention, let alone link any of the actions to particular obligations under the Convention. In the Court's own words, such a written exchange of claims and directly opposed counterclaims may evidence the existence of a dispute, but it does not constitute attempts at negotiations between the parties. In fact, this exchange provided a prelude to the ensuing pre-negotiations. Over the next 7 months, from December 2020 to July 2021, the parties engaged in pre-negotiations, negotiations about negotiations, or talks about talks. 7 months of pre-negotiations may seem a long time. However, it must be remembered that the parties had not met bilaterally without a mediator for almost 30 years. The technical discussions thus served as confidence-building measures prior to commencement of negotiations related to Armenia's third complaint. Such pre-negotiations are a general feature of the relations between the parties. For example, on the 26th of May 2022, the Armenian Minister for Foreign Affairs stated with regard to possible peace negotiations between the parties, and I quote, "Armenia and Azerbaijan are still holding negotiations about negotiations." In their pre-negotiation correspondence and meetings, the parties focused on procedural modalities, scheduling timetables, scope and topics for the discussions to be held on the alleged violations of the third, and the agenda for their meetings. For example, on the 22nd December 2020, Armenia suggested to start with the format and process of further negotiations. On the 3rd of March 2021, Armenia expressed its hope that, I quote, "the parties will continue approaching their initial procedural matters in the same constructive fashion with a view to promptly reaching agreement on the remaining open questions of modalities of further negotiations." Mr. President, members of the Court, as you can see on screen, it was only on the 3rd of May 2021 that the parties confirmed the 12-point agreed procedural modalities for their substantive discussions. However, this was not the end of the pre-negotiations. The parties continued to discuss the topics for their negotiations and the scheduling of the substantive negotiations. On the 31st of May 2021, the parties presented the topics which they wanted to address during the substantive negotiations. In its presentation on the scope of the negotiations, Armenia identified several topics which had not been included in the first list of alleged convention violations in its letter of 11th November 2020. The newly introduced topics included allegations of engagement in practices of ethnic cleansing, suppression of civil society organizations working towards reconciliation with Armenia, and failure to provide Armenians with equal treatment before tribunals and all other organs administering justice. None of these allegations could have been the subject of negotiations for the simple reason that none had been made before. The two-page list of Armenia's topics to be discussed at the substantive talks was phrased in very general terms and did not include any specific examples, facts, or evidence of alleged violations. Armenia also stated that it intended to discuss the remedies at the talks, but did not specify any remedies in connection with the alleged third violations. Without any of those specifics, a substantive discussion of alleged third violations was still impossible at that stage of the pre-negotiations. That there were no substantive negotiations has also been confirmed by Armenia on no less than 4 occasions. On the 30th of April 2021, Armenia noted the length of time, I quote, without any substantive discussions having been held. On the 22nd of May 2021, Armenia stated that it expects no further delay to the commencement of substantive negotiations on its claims under the third. On 3rd of June 2021, it noted that substantive negotiations still have yet to begin. And on the 22nd of June 2021, it stated that it was ready to commence meaningful substantive negotiations. Armenia seems to take the view that substantive negotiations finally started on 15-16 July 2021. In its letter to Azerbaijan, dated 9th July 2021, Armenia stated with regard to the proposed schedule of meetings that it trusted that this proposal would allow substantive negotiations to commence promptly on 15th July. According to the schedule agreed between the parties, as you can see on the screen, at the meeting on 15-16 July 2021, Armenia presented its claims and requested remedies. This was the first time that Armenia presented any specific allegations, set out its legal position, and identified the remedies it was requesting. At the meeting on 31st of August 2021, Armenia presented its replies. The two meetings were thus devoted solely to the oral presentation of the claims and replies. There was no discussion of those claims and replies at these meetings or in subsequent correspondence. In fact, no discussion was foreseen at that stage. The parties had expressly agreed to schedule the presentation of claims and replies some 6 weeks apart in order to allow them to prepare their replies. By 15 September 2021, which is labeled on the screen as the end, when Armenia informed Azerbaijan that it considered the negotiations to have failed, all the parties had done was raise allegations of third violations and present their opposing positions on the facts and the law. In the words of the court, the parties had exchanged a series of accusations and rebuttals. What they had not done was engage in any discussion with a view to resolving the dispute. Azerbaijan therefore submits that prior to 16 September 2021, when Armenia instituted the present proceedings, there had been no negotiations. In fact, negotiations in terms of Article 22 of CERT had not even started. Mr. President, members of the court, there were not only no negotiations, but Armenia never made a genuine attempt at such negotiations. It never attempted to engage in any meaningful discussion with Azerbaijan with a view to resolving the dispute. It is clear from the evidence that from the outset, Armenia's only aim was to bring its allegations against Azerbaijan before this court. This is confirmed by its very first diplomatic note of 11 November 2020, when it invited Azerbaijan to enter into negotiations for the purpose of addressing and remedying the alleged third violations. This invitation was immediately followed by an ultimatum to respond and a threat of legal action. Armenia stated, and I quote, "Should Azerbaijan reject this invitation or fail to respond to it within no more than a month from the date of receipt of this letter, or should any purported negotiations become futile, Armenia reserves the right to seek to settle the dispute in accordance with the procedure described under Article 22 of the Convention." End of quote. Before negotiations could even start, Armenia already spoke of purported negotiations and their futility. It implicitly threatened that if it did not get its way, it would simply declare the futility of the negotiations and take the dispute to the court. But discussions with a view to resolving the dispute cannot be based on threats, but require openness to the other party's position, flexibility, and the ability to compromise, none of which has been shown by Armenia. Proceedings before this court were at the forefront of Armenia's mind throughout the pre-negotiations. Thus, it was of the greatest importance to Armenia to be able to use material from the negotiations to prove that the negotiations had failed. For 3 weeks, the pre-negotiations were solely concerned with Armenia's wish to include in the agreed procedural modalities a passage that would allow Armenia to prove as a matter of fact that negotiations had in fact failed. Before negotiations had even started, Armenia was already more concerned with their failure than with making them a success. This is not what a genuine attempt at negotiations looks like. Mr. President, throughout the pre-negotiations, Armenia adopted a totally unrealistic and unreasonable position with regard to the time necessary for the substantive negotiations. Armenia accused Azerbaijan of multiple different violations of numerous third obligations, with underlying facts spanning, in Armenia's own words, past decades. The magnitude of the dispute is demonstrated by the fact that Armenia has now submitted to this court a 755-page memorial accompanied by 297 annexes totaling 1,220 pages. In these proceedings, Armenia requests the court to rule on 10 alleged breaches involving numerous third provisions and to provide at least 10 different remedies. Mr. President, members of the court, how many days would you allocate for negotiating such a substantial dispute? Probably months, if not years. Armenia, on the other hand, initially suggested just 1 day, with a second day held in reserve for possible further discussion on Armenia's claims. While Azerbaijan pointed out on numerous occasions that a meaningful discussion of the allegations requires more time, Armenia in the end only agreed to a schedule that allocated 2 days for the presentation of its claims and requested remedies, and gave Azerbaijan another 2 days to present its replies. 4 days in all. Armenia initially suggested that each day consists of 5 hours and 30 minutes of actual presentation time, which would have meant a total of 22 hours for both parties' presentations. In the end, I was told the actual time used for these 2 presentations was less than 7 hours. The allocation of 7 hours for the presentation of claims and replies cannot be considered a genuine attempt at negotiations with regard to settling a dispute of this magnitude. The present case may be contrasted with a third case between Ukraine and Russia, which was of similar magnitude. In that case, Ukraine sent 19 diplomatic notes to Russia, expressly referring to the rights and obligations under the third and the alleged violations of the Convention, and providing Russia with extensive and detailed records of alleged acts of racial discrimination. During 3 rounds of face-to-face meetings, Ukraine engaged with Russia on the facts and circumstances of specific discriminatory acts and sought Russia's responses and explanations. Ukraine also provided responses to Russia's questions concerning specific incidents, both during the meetings and in follow-up diplomatic correspondence. It is against this background that the court observed that, I quote, "Negotiations between the parties lasted for approximately 2 years and included both diplomatic correspondence and face-to-face meetings, which, in the court's view, and despite the lack of success in reaching a negotiated solution, indicates that a genuine attempt at negotiation was made by Ukraine. End of quote. There is no similar evidence of a genuine attempt at negotiation in the present case by Armenia. Mr. President, during the pre-negotiations, Armenia also paved the way for unilaterally declaring the negotiations to have become futile. While initially Armenia suggested that the parties jointly assess whether further negotiations are constructive in resolving the dispute, it later reserved for itself the right to assess if further negotiations might be constructive. In the end, it dropped any reference to such assessment. In particular, it did not agree to Azerbaijan's suggestion that after the September session, the parties shall mutually assess their progress and whether there exists a clear path forward to amicable settlement of all or parts of their claims. Such an approach cannot be considered a genuine attempt at good faith negotiations. On 15 September 2021, at the meeting that was actually reserved for the presentation of Armenia's replies to Azerbaijan's own third claims, Armenia rejected Azerbaijan's proposals for remedies outright, without engaging with them. It simply unilaterally declared that the negotiations had failed and walked away. Again, not a genuine attempt at negotiations. Less than 24 hours after declaring that the negotiations had failed, Armenia submitted an 82-page application instituting proceedings against Azerbaijan for alleged violations of CERT, accompanied by a request for the indication of provisional measures. The detailed application was accompanied by 62 annexes. 10 of these annexes were accompanied by certified translations, which had all been prepared between the 2nd and 13th of September 2021. Now, everyone familiar with cases before this court will understand that such an elaborate application requires several months of preparation. Work on these documents must have started well before Armenia even presented its claims to Azerbaijan on the 15th of July 2021. Armenia's conduct clearly shows that it never made a good faith attempt at settling the dispute by negotiations. It never gave negotiations a chance. It treated its exchanges with Azerbaijan as no more than a formality to go through in order to do what it had planned from the start: initiate proceedings before this court. Mr. President, members of the court, with no negotiations and no genuine attempt at negotiations, that basically is the end of Armenia's application. If the court should find, however, that a mere presentation of Armenia's claims on 15-16 July and the presentation of Azerbaijan's replies on the 30th, 31st of August were sufficient to constitute substantive negotiations, or that Armenia, despite of what has been said, made a genuine attempt at such negotiations, the court must decide whether Armenia pursued the negotiations as far as possible, with a view to settling the dispute. As the court held in Georgia versus Russia, to make this determination, it must ascertain whether the negotiations failed, became futile, or reached a deadlock before the application was submitted to the court. The court's inquiry into the sufficiency of negotiations is a question of fact to be considered in each case. It is not for Armenia simply to declare unilaterally that negotiations failed. Indeed, Armenia has not provided any evidence that it pursued the negotiations as far as possible with a view to settling the dispute. In past cases, the court has found that negotiations have failed or reached the point of futility or deadlock when the parties' basic positions had not subsequently evolved after several exchanges of diplomatic correspondence and/or meetings. In order to qualify as negotiations in terms of Article 22, these exchanges of diplomatic correspondence and meetings must, of course, refer to the substantive obligations under CERT. Armenia and Azerbaijan set out their positions on 15, 16 July and 30th and 31st of August 2021, respectively. There were thus not several exchanges of diplomatic correspondence or several meetings, but just 2 meetings in which each side set out its position for the first time. Meetings with such a narrowly defined purpose cannot form the basis for finding that positions have not evolved or that no progress has been made in terms of substantive matters. It is difficult to see how Azerbaijan's position could have evolved and how progress in reaching common ground on substantive issues could have been made when the discussions were terminated by Armenia shortly after Azerbaijan had set out its position for the first time. A position can only evolve when it is given a chance to evolve. At the provisional measures stage, the court found that, based on information available then, it seems that the position of the parties remained unchanged and that their negotiations had reached an impasse. As I've already shown, the court is not bound by this finding. The finding is also incorrect. Progress on substantive matters was indeed made. In its reply to Armenia's claims and requested remedies, Azerbaijan did not rebuff the idea of remedies, but in the interest of resolving the dispute, submitted a proposal for joint actions. Several of the 13 actions proposed by Azerbaijan directly corresponded to the remedies requested by Armenia, which is demonstrated by the fact that they also correspond to the remedies Armenia now requests before this court. Mr. President, members of the court, let me give you just 3 examples of progress, albeit tentative, that has been made in just 2 exchanges. First, Armenia asked the court to order Azerbaijan to allow the safe and dignified return of displaced ethnic Armenians to their homes and places of origin. In its proposals, Azerbaijan had offered to facilitate the return of all refugees and internally displaced persons displaced by the conflict who desire to return to their homes. Second, Armenia asked the court to order Azerbaijan to guarantee the right of ethnic Armenians within its jurisdiction to equality before the law, notably in the enjoyment of the human rights and fundamental freedoms. In its proposals, Azerbaijan had offered to take steps to provide for the rights of everyone, regardless of ethnic origin, to equality before the law and the equal enjoyment of fundamental human rights. Third, Armenia asked the court to order Azerbaijan to adopt immediate and effective measures in the fields of education with a view to combating prejudices which lead to racial discrimination against ethnic Armenians. In its proposals, Azerbaijan had offered to assess educational materials and remove any anti-Armenian statements from textbooks and other materials used in schools. In addition, in response to Armenia's claims with regard to the military trophies park, Azerbaijan offered in its reply to acknowledge that the use of monikers to depict Armenian soldiers in the military trophies park has inflamed tensions between the two states, and to consider removing some monikers depicting Armenian soldiers and ensure that the park tour guides do not use inflammatory language inciting discrimination against Armenians. All these proposals by Azerbaijan show that the negotiations were not at an impasse or futile. They had just started. Azerbaijan expressly confirmed its willingness to discuss its proposals to resolve Armenia's claims and to consider any other reasonable proposal put forward by Armenia. However, rather than putting forward any proposals, Armenia just walked away. That concrete results could be achieved when the parties constructively engaged was shown by the exchange of Armenian personnel for information on a portion of landmines planted by Armenia in Azerbaijan's liberated territories. The same could have been the case with regard to the third complaints. Armenia did not engage with Azerbaijan's proposals for remedies, but summarily rejected them, apparently because Azerbaijan did not concede Armenia's claims outright. Negotiations, however, do not mean that one party simply submits to the demands of the other. Armenia also took exception to Azerbaijan's proposals being made on a no prejudice basis. But diplomatic negotiations are often conducted on a no prejudice basis in order to facilitate the free exchange of proposals. During the pre-negotiations, Azerbaijan had expressly suggested including a no prejudice clause in the agreed procedural modalities. Armenia's reason for unilaterally terminating the negotiations thus cannot be considered valid. There is no question of the negotiations failing due to a lack of progress on substantive matters. The only reason why negotiations were not pursued as far as possible is Armenia's unwillingness to do so. As negotiations have not been exhausted, the precondition of negotiation is thus not met. Let me conclude. According to the Court's own definition of negotiations in terms of Article 22, the parties never conducted negotiations, and Armenia also never made a genuine attempt at such negotiations. Even if it did, by unilaterally breaking off the negotiations when they had only just begun, Armenia did not pursue these negotiations as far as possible. If Armenia's conduct in this case indeed sufficed to meet the requirement of negotiations, this procedural precondition would not just be downgraded to a mere formality, it would become a farce with far-reaching consequences for future cert cases more generally. For these reasons, the Court should uphold Azerbaijan's first preliminary objection and dismiss Armenia's application for lack of jurisdiction under Article 22 of the cert. That brings me to the end of my presentation. I thank the Court for its kind attention. Mr. President, it might now be a convenient time for a short break. Otherwise, may I ask you to call on Mr. Wordsworth to present Azerbaijan's second preliminary objection. Thank you.
I thank Professor Talman for his statement. Before I invite the next speaker to take the floor, the Court will observe a 10-minute break. The sitting is suspended. Please be seated. The sitting is resumed. I now invite Mr. Wordsworth to address the court. You have the floor, sir.
Mr. President, members of the court, it is a privilege to appear before you and to have been asked by Azerbaijan to introduce its objections to jurisdiction rationi materiae and then to develop the objection so far as concerns alleged breaches of CERD concerning alleged murder, torture and inhumane treatment of ethnic Armenians. Our basic point is that what should really be claims for breach of international humanitarian law in the context of active hostilities are impermissibly being presented by Armenia as CERD claims. The key question for present purposes is whether, as required by Article 22 of CERD, Armenia's claims give rise to a dispute with respect to the interpretation or application of this convention. The court is very familiar with this wording, and this is now the fourth case in which the court has had to consider the extent of its jurisdiction rationi materiae under Article 22, with the issue also falling for consideration next week so far as concerns Armenia's jurisdictional objections to Azerbaijan's CERD claims. But the current cases do have two unusual features which it's useful to focus on up front. First, both parties implicitly accept in their respective preliminary objections that certain of the claims are capable of engaging CERD. This stands in marked contrast to the Georgia and Russia, Ukraine and Russia, and Qatar and UAE cases. In the current cases, there is no objection rationi materiae in respect of certain of the claims, and most obviously the two parties' respective allegations of ethnic cleansing. So far as concerns the objections before you today, these have been carefully restricted and concern only discrete claims of misconduct that in essence concern periods of active hostilities. That is, the objection rationi materiae to Armenia's freestanding claim that Azerbaijan has breached Articles 2.1a, 4a and 5b of the CERD by engaging in the discriminatory murder, torture and inhumane treatment of ethnic Armenians, insofar as that claim concerns 1. Alleged acts against Armenian military personnel in the course of active hostilities, and 2. Alleged acts against Armenian civilians in active hostilities, insofar as these have not been particularized with reference to specific evidence of racial discrimination. And I'll be making the submissions on the issues arising here. There is then the objection rationi materiae to Armenia's freestanding claims that Azerbaijan has breached Articles 2 and 5a CERD by engaging in practices of discriminatory arbitrary detention of ethnic Armenians and by engaging in practices of discriminatory enforced disappearances of ethnic Armenians. And Professor Boisson de Chazorn will shortly be addressing these claims. These confined objections are brought because these Armenian claims conflate alleged breaches of international humanitarian law with CERD. And although Armenia has put considerably more effort in its written observations to seeking to tie its allegations to racial discrimination, an impermissible conflation remains. The court is being asked to allow through to the merits a seemingly unrestricted series of allegations of executions, targeted shootings, indiscriminate attacks, mistreatment, unlawful detention and enforced disappearance in the context of active hostilities in an armed conflict. All of this conduct would, if proven, constitute very serious breaches of international humanitarian law. And it is the attempted pulling across of a broad and open-ended series of potential violations of IHL into CERD that motivates the current objections ratione materiae. The second unusual feature of the current case is that there is much common ground as to the correct legal test and approach to be followed, and no doubt the parties' respective claims and respective jurisdictional objections have had a usefully corrective impact against the adoption of any extreme positions on the law. Thus, it is common ground between the parties that the test at this jurisdictional stage is whether the conduct complained of is capable of falling within the scope of the Convention. And this will naturally also be the test under consideration next week in the context of the objections to Azerbaijan's claims for breach of CERD. Both parties also recognise that the Court has upheld preliminary objections ratione materiae under CERD, where it concluded that the alleged discrimination was based on a ground which is not specifically protected within the Article 1.1 definition of racial discrimination, and the allegations did not support an inference of discrimination based on one of the protected grounds. Thus, in Qatar and UAE, the Court held that while measures based on current nationality may have collateral or secondary effects on persons of a particular national or ethnic origin, this does not constitute racial discrimination within the meaning of the Convention. In the recent judgment in Ukraine and Russia, the Court reiterated that mere collateral or secondary effects on persons who are distinguished by one of the prohibited grounds do not, in and of themselves, constitute racial discrimination within the meaning of the Convention. This would be applicable, for example, where an Armenian citizen was detained after crossing into Azerbaijan unlawfully, bypassing the applicable border controls. In general terms, unless the allegations and evidence relied on show something other than mere collateral or secondary effects on ethnic Armenians, the Court should conclude that it lacks jurisdiction ratione materiae over the claims because they are not capable of constituting racial discrimination within the meaning of Article 1.1. It is also common ground between the parties that CERD can apply in an armed conflict as well as in peacetime, and that conduct which violates international humanitarian law can also implicate CERD. But this is only so if the conduct involves racial discrimination, as defined in Article 1.1 CERD, now on your screens, which concerns, so far as is relevant for today, any distinction based on national or ethnic origin which has the purpose or effect of nullifying or impairing the recognition, enjoyment or exercise on an equal footing of human rights and fundamental freedoms. At the same time, however, as the Court has previously recognised, international humanitarian law is the law applicable in armed conflict, which is designed to regulate the conduct of hostilities. This does not suggest the exclusion of international human rights law, CERD included, but it is common ground between the parties that the mere fact that peoples of two states at war are primarily of different ethnic origin, as they are in this case, does not, without more, transform every act of war into a distinction based on ethnic origin, so as to be capable of engaging CERD. It follows that a key question, both this week and next, is whether there has been some cognizable case of that something more, alongside the need for the no less essential case on the discriminatory purpose or effect. This leads to two further points. First, that requisite showing of something more is of very great importance. Although in their respective preliminary objections, both parties accept that certain of the claims made are capable of falling within CERD, it could not be appropriate to take a blanket approach and accept, without any closer inspection, that all apparent IHL violations that are claimed to have been based on racial discrimination are indeed capable of falling within the provisions of CERD. It appears critical for the Court to distinguish between conduct that is capable of giving rise to a claim for violation of international humanitarian law and conduct that is additionally capable of falling within the scope of CERD. As the Court has observed, the scope of CERD exclusively concerns the prohibition of racial discrimination on the basis of race, colour, descent, or national or ethnic origin. There is no wider gateway. And unless the Court controls that gateway at this jurisdiction stage, it risks sending the signal that many potential violations of IHL could be presented as CERD claims by reference to context alone, and hence will be determined by the Court at the merit stage, provided only that the applicant frames its claim with sufficient care. And pausing here, it is to be emphasised that armed conflicts frequently arise between states whose populations are predominantly of different national or ethnic origins. And in the course of such armed conflicts, there will, unfortunately, almost always be instances, or at least allegations, of, for example, mistreatment or wrongful detention, both as concerns members of the hostile state's armed forces and its civilians. But given the absence of an obvious avenue for bringing claims for breach of IHL before an international court or tribunal, that is, given the absence of a compromissory clause within the 1949 Geneva Conventions, there is a movement towards unduly creative methods to bring cases concerning armed conflict before international courts and tribunals, with the obvious risk of IHL complaints being inappropriately framed as CERD claims. The views expressed by Judge Youssef in his declaration of 22nd February 2023 offer an expression of this concern. And there is plainly a need for at least some caution. Second, the need for something more cannot be satisfied by the existence of a general backdrop of extreme hostility between the combatants to an armed conflict and the respective populations. Nonetheless, according to Armenia in its observations, and I quote, Azerbaijan's suggestion that the Armenophobia permeating Azerbaijani society is irrelevant is simply misplaced, not least because it reveals that the conduct at issue in this case is neither exclusively directed at Armenian nationals nor exclusively related to wartime hostilities. This is problematic. Leaving to one side the self-serving use of terms like Armenophobia, Azerbaijan has not said that the general background of anti-Armenian sentiment is irrelevant, and it's notable that Armenia does not footnote to any specific passage in Azerbaijan's preliminary objections. Rather, the existence of anti-Armenian sentiment may have some relevance as background context, But that is all. By contrast, Armenia is suggesting that the so-called Armenophobia means that the conduct at issue in this case is not exclusively related to wartime hostilities. That is, it is being presented as distinguishing the current case from wartime hostilities in which IHL and other norms alone would apply. Indeed, almost 10 pages of Armenia's written observations are devoted to presenting general Armenophobia as a relevant factor. But anti-Armenian sentiment, just like the anti-Azerbaijani sentiment that exists on the other side, must be placed in its proper context. Animosity to a hostile state and its armed forces has always been present in armed conflicts and often extends to the hostile state's population. Such animosity during time of war has always included the use of insults and derogatory terms that focus on the nationality of the enemy armed forces and which could be portrayed as racist. Examples would include the terms used by the Americans, British and Russians to describe the Germans during the Second World War and vice versa, or more recently, no doubt, the use of language by both sides in the ongoing armed conflict between Ukraine and Russia, which has not, however, been co-opted into the construction of a third claim brought by reference to conduct since February 2022. And another example is the present case, which involves a long-running armed conflict and almost 30 years of military occupation by Armenia of part of Azerbaijan's internationally recognized sovereign territory, from which the Azerbaijani population was ethnically cleansed. And it is to be recalled that the conflict resulted in more than 1 million internally displaced Azerbaijanis. The mere existence of the resulting anti-Armenian sentiment, just as the parallel existence of anti-Azerbaijani sentiment, does not demonstrate racial discrimination for the purposes of Article 1, third. As a general matter, as the Court has previously recognised in Qatar and UAE, declarations criticising a state or its policies cannot be characterised as racial discrimination within the meaning of third. Of course, the context of that case, with no armed hostilities and no military occupation, was very different, as were the declarations at issue. But the basic point that insults or criticism or bitter hostility are not to be conflated with racial discrimination within third applies in the current case, with all the more need for attention to the distinction given the risk for conflation when one is concerned with the hostile rhetoric common in times of war. And as to this, it is to be recalled that Azerbaijan's objection concerns alleged conduct during active hostilities, that is, alleged breaches by Azerbaijan during the period of active hostilities in April 2016, during the Second Karabakh War in 2020, and at certain later dates, including in September 2022, when there were certain clashes along the undelimited border between the two states. And as a final point on the relevant tests, even if the Court were satisfied at this stage that the criticism or hostility could be characterised as entailing an element of racial prejudice, that would still not be enough on its own. Such statements could only be regarded as relevant evidence of racial discrimination if the other factors within Article 1.1 are present, including the requirement of purpose or effect with respect to the specific alleged violations. With these factors in mind, I turn to Azerbaijan's objection to Armenia's claim concerning engaging in the discriminatory murder, torture, and inhumane treatment of ethnic Armenians. As explained in its letter of 5 April 2024, with the relatively low threshold that applies at this jurisdictional phase in mind, and likewise the further particularization in Armenia's written observations of its factual allegations and the evidence relied on, Azerbaijan has further confined its objection. This is now focused on allegations in the periods of active hostilities and one, inadequately particularized allegations of racial discrimination concerning Armenian civilians, and two, the alleged acts against Armenia's armed forces personnel. It is with respect to these two elements of the claim that it is most evident that Armenia has failed to put before the court the something more that is required to distinguish its claim from allegations that otherwise would solely be a matter for IHL and other non-CERD norms applicable in the context of active hostilities within an ongoing armed conflict. It is also to be emphasized that unlike, for example, in the Ukraine and Russia case, and unlike most of Armenia's other claims in this case, Armenia's claim with respect to alleged discriminatory murder, torture, and inhumane treatment is not framed by reference to an alleged systematic campaign or practice of racial discrimination. Instead, it appears to concern a number of alleged individual acts and specific episodes said to constitute racial discrimination. Now, a claim based on alleged systematic campaign or practice is more difficult to make good at the merits, because obviously the existence of that campaign or practice must be established. But as a corollary, at the jurisdictional phase, it may be less difficult to establish that the claim is capable of falling within CERD, because the very existence of the claim is predicated on there being a systematic campaign or practice of specifically racial discrimination. Alleged instances of racial discrimination in that context are put forward as examples of an overarching practice, and it is some evidence of the practice that must be put before the court, without the same need to tie each individual instance relied on to specific instances of alleged racial discrimination. By contrast, where, as here, there is a freestanding claim on discriminatory murder, torture, and inhumane treatment, Armenia must satisfy the court that the instances of allegedly unlawful conduct are themselves, in each case, capable of falling within CERD. In other words, within this discrete claim, and as to each of the instances relied on, there must be the requisite element of racial discrimination adequately pleaded. To take an example for what might otherwise seem a rather abstract point, at paragraphs 3.242 and 3.243 of its memorial, Armenia alleges, referring to the Second Karabakh War, that throughout the war, Azerbaijan deliberately used weapons causing extensive and indiscriminate harm to civilians. For example, in residential areas outside of its direct control, Azerbaijan repeatedly used cluster munitions which pose an immediate threat to civilians, even in the densely civilian-populated city of Stepanakert, Azerbaijan also resorted to the use of incendiary weapons, including white phosphorus munitions, may cause deep burns all the way down to and even through the bone, and can reignite even after initial treatment. In total, during the 44 days of war, Azerbaijan destroyed an estimated 14,000 civilian structures, including homes, markets and infrastructure vital to the survival of the local population, such as bridges, electricity, telecoms and gas and water supply systems. Azerbaijan's concern is that through the allegation of use of a certain type of weapon or of indiscriminate harm more generally, that is, matters plainly governed by IHL, Armenia is seeking to bring within SERD the entirety of a period of active hostilities, thus establishing a wholly open-ended jurisdiction with respect to, for example, alleged violence caused to civilians of Armenian ethnicity. If this were just being presented as background to specific allegations that were then tied back to specific acts of racial discrimination, then that would be less problematic. But it does not appear to Azerbaijan that this is so. Indeed, these paragraphs form part of the memorial that Armenia presents as being direct evidence of Azerbaijan's racially motivated violence. By way of another example, Armenia relies on the following allegations as part of such direct evidence. As noted above, in September 2022, Azerbaijan launched a full-scale armed attack against the sovereign territory of Armenia, using heavy artillery and drones to target not only military units and installations, but also towns and villages on the Armenian side of the international border between Armenia and Azerbaijan. Azerbaijan's aggression was swiftly met with international condemnation and calls to withdraw its troops. The attack resulted in the deaths of at least 207 Armenian servicemen and 4 civilians, a number which is likely to rise given the number of those still missing as of the date of this memorial. Injuries to other servicemen and civilians, and significant damage to civilian infrastructure. Armenia's claim of breach of SERD would appear to include these 4 civilians who, according to Armenia, were very unfortunately killed during a military operation which Armenia wishes to characterize as unlawful. Yet there is nothing remotely specific to suggest that this loss of military and civilian life was based on racial discrimination. And there are various other examples. Azerbaijan accepts that Armenia has made certain adequately particularized allegations of mistreatment of ethnic Armenian civilians in the armed conflict, accompanied by alleged racial discrimination. And it is accepted that such complaints are on their face capable of falling within SERD. Although Azerbaijan anticipates defeating Armenia's claims at the merits phase. But otherwise, the mere listing of alleged civilian deaths or allegations as to the use of indiscriminate weaponry should not be enough, in effect, to bring into play at the merits phase the whole conduct of the Second Karabakh War and likewise other phases of active hostilities, so far as concerns civilian deaths and injury. I turn to the allegations of murder, torture or inhumane treatment of Armenian military personnel during active hostilities. And here, in this context of a bitter armed conflict and prolonged military occupation of Azerbaijan's territory, there is an even greater and pressing need for the something more to demonstrate that what appear to be very serious allegations of breach of IHL amount to conduct capable of engaging CERD. In its written observations at paragraph 48, Armenia has sought to meet Azerbaijan's objection by placing particular weight on a number of incidents recorded on video that appear to show certain shocking mistreatment, accompanied by the use of specific language that is said to show that the mistreatment was based on racial discrimination. But care is needed here, as CERD will not be engaged in cases where the military personnel of the opposing forces have been captured or killed in an armed conflict, and alleged mistreatment merely involves some form of derogatory and insulting behaviour. In circumstances where it is common ground that the mere fact that the peoples of two states at war are primarily of different ethnic origin does not, without more, transform every act of war into a distinction based on ethnic origin, it will be necessary to make some showing that alleged mistreatment is not due to an individual's status as an enemy combatant, but is indeed due specifically to ethnic origin. In Armenia's first example, it refers to a video purporting to show Azerbaijani soldiers mutilating the corpse of a dead Armenian serviceman and claiming that we will eliminate their race. However, the word that is being translated as race by Armenia is a Russian word, sort, the word for sort or kind, and the actual words being directed towards the Armenian soldier are that we will destroy their sort. And this is language used in the context of immediately preceding statements concerning taking revenge for having killed our strong guys, which appears to be a reference to Azerbaijani military personnel. By reference to this correct translation, the mistreatment, although shocking and very regrettable, appears to have been based on an individual's status as an enemy combatant, not due specifically to ethnic origin. The other examples of alleged mistreatment of Armenian servicemen in or immediately subsequent to hostilities show the use of language such as the disgraceful people, or they are not human beings, or insulting references to dogs, which would not be enough to turn what would be an apparent breach of IHL, however serious, into a claim capable of falling within CERD. Otherwise, almost every significant or long-running conflict involving different ethnic groups would be capable of generating CERD claims. Armenia also says that its videos represent the tip of the iceberg. But this is not a claim based on a practice or a campaign. It is a claim based on alleged acts. And Armenia can either tie back certain alleged acts to racial discrimination, or it cannot. It also relies on multiple witness statements in its Annex 291, but these likewise do not indicate alleged mistreatment based on racial discrimination, as opposed to the existence of derogatory insults. Armenia has put forward what it presumably considers to be its best examples from its Annex 291 at paragraph 53 of its observations. In each case, a prisoner of war has allegedly been mistreated, accompanied by language such as Armenians have been nomads and did not have a state, and they seized the Azerbaijanis' historic lands, or Armenians should not exist. Armenia would presumably again say that this is the tip of an iceberg, but the iceberg appears to be one of alleged mistreatment and insult of prisoners of war based on their status as combatants in the active hostilities phase of an armed conflict, and not matters for cert. Azerbaijan in no way seeks to question the potential importance or role for CERD in an armed conflict. However, it does consider that even at the jurisdictional phase, close attention is required to where, by reference to the allegations presented in a given case, the court should draw the boundary between colourable breaches of CERD and that matters which would be for international humanitarian law and other non-CERD norms alone. The Convention was not intended for all apparent breaches of IHL in an ethnic conflict, and that much is common ground between the parties. Armenia accepts it must demonstrate something more, even at the current phase. And for example, even taking into account the backdrop of the so-called Armenophobia, the existence of civilian casualties, or the use of cluster bombs, or some showing of the use of derogatory and insulting language towards members of the opposing armed forces, cannot be enough. Mr. President, members of the Court, I thank you for your attention and ask you, Mr. President, to call upon Professor Boisson de Chazourne.
I thank Mr. Wordsworth for his statement. Je donne maintenant la parole à Madame la professeure Laurence Boisson de Chazourne. Madame.
Madame. President, Vice President, members of the Court, it is a privilege for me to appear before you today on behalf of Azerbaijan. It is my task to expand on Azerbaijan's second and third objections with regard to your court's jurisdiction ratione materiae under third. The second objection raised by Azerbaijan concerns Armenia's allegations, such as they are set out in Part 6, Chapter 3, Section 3 of its memorial, according to which Azerbaijan arbitrarily detained ethnic Armenians. Azerbaijan's third objection concerns Armenia's allegations, as set forth in Part 6, Chapter 3, Section 4 of its memorial, that Azerbaijan allegedly subjected ethnic Armenians to enforced disappearances. According to your court's well-established jurisprudence, the criterion of jurisprudence aims at establishing whether the conduct complained of, and I quote, is capable of falling within the scope of CERD. However, in the present case, the court is faced with a different question. As Mr. Wordsworth pointed out, this question concerns the distinction to be made between conduct which results in a breach falling under international humanitarian law and conduct capable of falling under CERD. If such a distinction is not established, the appropriate limits of the jurisdiction ratione materiae of the High Court under CERD might not be complied with. Yet Armenia's allegations and evidence, which are the subject matter of Azerbaijan's preliminary objections, should they be deemed to be well-founded, implicate international humanitarian law and offer no basis to conclude that they fall within the scope of CERD. The absence of any jurisdictional basis under international humanitarian law cannot serve as a pretext for Armenia to attempt to make its claims fall within the scope of CERD. In view of these considerations, please allow me to now turn to Azerbaijan's second objection. Armenia complains that Azerbaijan has breached Articles 2 and 5A of CERD by engaging in practices of discriminatory arbitration of ethnic Armenians. Armenia's allegations with regard to wrongful detention, which are the subject matter of Azerbaijan's second objection to your court's jurisdiction, ratione materiae, are divided into two categories. First of all, they concern Armenian nationals who crossed the border with Azerbaijan unlawfully. And secondly, they concern prisoners of war captured during the Second Karabakh War. I will revert to these two categories in a moment. Azerbaijan would like to specify from the outset that it repatriated the majority of prisoners of war captured during the armed conflict pursuant to its obligations under international humanitarian law and the Trilateral Declaration. Armenians currently held by Azerbaijan, whose number is limited, were charged or convicted of serious crimes including torture, mercenary activities, crimes which Azerbaijan has the duty and right under international law and under its domestic law to investigate and prosecute. From the outset, it should be noted that the parties agree that at this stage, the court does not need to weigh or assess evidence and the merits in order to dismiss a claim. As the court noted in its judgment Ukraine against Russia regarding preliminary objections, the court's task, as laid down in Article 79 of its rules, is merely to consider, and I quote, to consider the questions of law and fact that are relevant to the objection to its jurisdiction. Armenia's allegations, even were they to be held as well-founded, do not fall within CERD, as Armenia has not adduced sufficient evidence to reach the conclusion that Azerbaijan's alleged practices of discriminatory arbitrary detention were based on ethnic origin. On the contrary, the evidence adduced by Armenia clearly shows that all of the detainees were captured during active hostilities or were detained on grounds of their alleged unlawful activities. Hence, Azerbaijan, relying on the statements by Judge Yusuf, considers that the evidence produced by Armenia to substantiate these allegations, and I quote, has nothing to do with CERD and everything to do with the humanitarian law jus in bello, applicable between two states engaged in an armed conflict. Let us now turn to the first category of detainees concerned by the claim, namely Armenian nationals who crossed the border with Azerbaijan unlawfully. As it can be seen from Armenia's allegations, these persons were detained by Azerbaijan because they had entered into Azerbaijani territory unlawfully and not because they were ethnic Armenians. It need hardly be recalled that border regulation and control fall within the sovereignty of Azerbaijan, which it exerts both with regard to Armenian nationals and indeed with regard to nationals of any other country who might cross the border unlawfully. Notwithstanding what has just been said, Armenia refers to some cases of Armenian nationals in an attempt to establish the existence of a so-called pattern of detention on the part of Azerbaijan. Furthermore, Armenia relies on certain decisions handed down by the European Court of Human Rights in order to turn these allegations into allegations of racial discrimination under CERD. But as the court observed in the case Qatar against the United Arab Emirates, it is for the court in the present case to determine the scope of CERD, which exclusively concerns the prohibition of racial discrimination on the basis of race, colour, descent, or national or ethnic origin. The court notes that the regional human rights instruments on which the jurisprudence of the regional courts is based concern respect for human rights without distinction of any kind among their beneficiaries. End of quote. The judgments of the European Court of Human Rights do not help to ascertain whether the alleged detentions are capable of being based on ethnic origin. The European Court of Human Rights did not weigh and assess the circumstances surrounding each of the individual detentions and the differences amongst them, nor has it taken into account the fact that these detainees were prisoners of war. Moreover, it did not seek to establish whether the detentions were based on the ethnic origin of the persons concerned. Mr. President, members of the court, Azerbaijan contends that these individuals were detained on the ground of their implication as members of the Armenian armed forces, saboteurs, or spies. Their detention did not have anything to do with their ethnic origin. Azerbaijan detained these individuals as prisoners of war in accordance with the 1949 Geneva Convention relative to the treatment of prisoners of war, the so-called Third Geneva Convention. Matters pertaining to prisoners, their conditions and exchange of prisoners of war between Azerbaijan and Armenia were dealt with by the International Committee of the Red Cross. Indeed, throughout their detention, Azerbaijan communicated with the ICRC on a regular basis as matters concerning prisoners of war are dealt with by the former. As the court knows, under the 4 Geneva Conventions and Protocol 1, the ICRC is entrusted with a specific mandate to take action in case of international armed conflict, and in particular, the committee has the right to visit prisoners of war and civilians who are detained. As Azerbaijan has previously explained to the court during previous hearings, Azerbaijan detained individuals who entered into the territory of Azerbaijan because they were suspected of being involved in attacks against Azerbaijani civilians and servicemen. All of this clearly shows that the detentions, which are the subject matter of this application, are not capable of being based on ethnic origins. To establish jurisdiction under CERD, Armenia should show more than the mere fact that these individuals were Armenians. I would now like to turn to the second category of detainees concerned by the application, namely the prisoners held in custody during the Second Karabakh War. Armenia acknowledges that these individuals were detained during and in the wake of the Second Karabakh War. A rapid examination of Appendix 297 of the Armenian Memorial, to be found in tab 4 of the judge's folders, attests to this. Armenia having itself pointed out that almost all the individuals who were captured or detained during or after the Second Karabakh War were prisoners of war. The columns entitled Status and Date of Capture in Appendix 297 clearly show that the persons were detained during the Second Karabakh War. Likewise, during the hearings on the request for provisional measures held in 2021, Armenia submitted a table of 45 persons detained by Azerbaijan, calling them all Armenian nationals and prisoners of war and civilians of Armenian ethnicity and nationality. Now, it is well established that discrimination based on nationality is not covered by CERD. Armenia's reference to the final observations of the CERD committee, dated 22nd of September 2022, is not relevant and certainly not decisive in order to ascertain whether the alleged detentions are capable of being based on ethnic origins. The CERD committee simply noted it was, and I quote, deeply concerned about allegations of arbitrary detentions and prisoners of war and other protected persons of Armenian ethnic or national origin. In this context, it is important to be mindful of the recent observation made by the court in the case Ukraine versus Russia, namely, and I quote, that the CERD committee does not take a position as to whether the respective reports are accurate and does not rely on first-hand evidence. That holds true in the present case. The observations by the CERD committee don't help Armenia because they do not take a stance on whether or not the alleged detentions were based on ethnic origins, which would allow Armenia to claim that its allegations fall within the scope of CERD. Armenia also refers to the European Parliament's resolution of the 20th of May 2021 regarding prisoners of war following the last conflict between Armenia and Azerbaijan, and Resolution 2391 of the Parliamentary Assembly of the Council of Europe on the humanitarian consequences of the conflict between Armenia and Azerbaijan, the Karabakh conflict. Mr. President, the titles of these two documents are telling and enlightening. They concern issues of armed hostility between Armenia and Azerbaijan and their consequences. These two resolutions fail to deal with the ethnic origin of the prisoners and do not serve in any way to conclude that the alleged detentions are capable of being based on ethnic origins. Allow me to briefly touch on Armenia's allegation that the detentions were purportedly arbitrary, an allegation based on unsubstantiated assertions that the criminal charges were not fairly prosecuted. Azerbaijan has not detained these individuals in breach of the safeguards of a fair trial and other legal requirements. Azerbaijan previously explained to the court that each individual brought to trial was tried and convicted by ordinary courts established in accordance with the requirements of a fair trial pursuant to Azerbaijan's international obligations. Members of the court, in the interest of accuracy, the individual rights protected under Azerbaijani law are set out in tabs 6, 7, and 8 of the judge's folder. Azerbaijan previously provided the court with the judicial decisions delivered by the Azerbaijani national courts, in which the initial charges were either reduced or dropped after the judges established that the evidence adduced did not suffice to substantiate them. Thus, for example, on the 2nd of July 2021, the Baku Court on Grave Crimes refused to uphold charges of terrorism or wrongful possession of firearms against 14 detainees for want of evidence, and considered that only the charges of unlawful border crossings were established. The detainees who remain in the custody of Azerbaijani authorities have been found guilty of grave crimes, including torture and murder. For example, 2 Armenian nationals are serving 20-year-long prison services for having inter alia tortured, killed and held hostage several Azerbaijani civilians and servicemen during the conflict between the two states. Several victims have described regular and brutal beatings by these Armenian soldiers. Azerbaijani's right to detain such persons is provided for under Article 119, paragraph 5 of the Third Geneva Convention, which specifies, and I quote, prisoners of war against whom criminal proceedings for an indictable offence are pending may be detained until the end of such proceedings and, if necessary, until the completion of the punishment. The same shall apply to prisoners of war already convicted for an indictable offence. End of citation. And although Armenia has not submitted this information to the court, several Armenians have been repatriated to Armenia following decisions handed down by the Supreme Court of Azerbaijan on the 8th of September 2022. And these decisions show that Armenian prisoners continue to enjoy the right to a fair trial and equal treatment before the courts in accordance with international norms.
Members of the court, the evidence clearly demonstrates that the detentions have no discernible link with ethnic origin, and they are entirely due to the fact that the detainees were fighting or were perceived as fighters, or that they were engaged in serious violations of the law. The court's observation in its order dated 7th of December 2021, according to which, and I quote, Armenia has not placed before the court evidence indicating that these persons continue to be detained by reason of their national or ethnic origin, unquote, should be borne in mind. These persons were detained because of their status as members of the Armenian army or as Armenian citizens suspected of having illegally entered Azerbaijani territory. Moreover, these detentions took place during active hostilities between Armenia and Azerbaijan. The mere fact that these wartime detainees are predominantly persons of Armenian origin does not automatically transform claims relating to their detention into claims that fall under cert. This is simply an unfortunate but predictable reality in an armed conflict with a state whose population is almost entirely made up of Armenians. In other words, the fact that the detainees are predominantly from one ethnic group is a reflection of the demographics of the state of Armenia that is involved in the conflict. It is not proof of discrimination based on ethnicity. The court should therefore make a distinction between claims that need to be examined at the merit stage, that is, claims concerning racial discrimination made by Armenia and by Azerbaijan against each other, and the claims falling under international humanitarian law that have nothing to do with CERD. To clarify, Azerbaijan does not contend that CERD is replaced by IHL in the context of an armed conflict. But Armenia's allegation, according to which the detentions complained of were purportedly arbitrary and discriminatory, cannot be examined under CERD. IHL is designed to regulate armed conflict and the conduct of hostilities. It is in this context that Armenia's allegations concerning supposed unlawful detention were made. Azerbaijan argues that the question of whether a detention is unlawful can only be settled by referring to the law applicable in times of armed conflicts. The Third Geneva Convention regulates in detail the release, repatriation and treatment of prisoners of war, whereas the Fourth Geneva Convention, relative to the protection of civilians in wartime, which is the Fourth Geneva Convention, addresses the internment or detention of protected persons. The provisions of both these conventions apply to all populations of countries in conflict. And I quote, without any adverse distinction based on race, nationality, religious belief, or political opinions, or any other distinction founded on similar criteria. End of quote. Furthermore, customary international humanitarian law provides that, and I quote, that states must investigate war crimes allegedly committed on their territory and, if appropriate, prosecute the suspects. End of quote. It follows that the court should reject Armenia's claims concerning the alleged unlawful detention of soldiers, military personnel, and other Armenian detainees because they do not fall within the court's jurisdiction ratione materiae. Mr. President, members of the court, I now come to the third and final objection of the lack of jurisdiction ratione materia of this court. Armenia is asking the court to adjudge that Azerbaijan has violated its obligations under Article 2 and 5A of the CERD by engaging in practices of discriminatory enforced disappearances of ethnic Armenians. End of quote. Azerbaijan contends that evidence exists demonstrating that Armenia's allegations concerning enforced disappearances are baseless. As noted by Azerbaijan's State Commission on Prisoners of War, Hostages and Missing Persons, after the Second Karabakh War, 1,730 bodies were discovered and handed over to Armenia. Following the military conflict on the undemarcated border between Armenia and Azerbaijan from 12 to 14 September 2022, 157 bodies were found and handed over to Armenia. Following the local anti-terrorist measures taken by Azerbaijani armed forces in Karabakh from 19 to 20th September 2023, 173 bodies of servicemen were retrieved and handed over to Armenia. Ladies and gentlemen, members of the court, Armenia asks you to consider that there is what it calls a practice of enforced disappearances. However, the facts that I have just mentioned show that there is no such practice of discrimination based on ethnic origin with regard to disappearances. Furthermore, Azerbaijan is prepared to cooperate with Armenian representatives to search for disappeared persons on both sides. This clearly demonstrates that Azerbaijan neither refuses nor conceals any information on disappeared persons as a result of armed conflict. And this does not mean that disappearances in the context of an armed conflict are based on ethnic origin. I can be brief on the third objection. Indeed, Armenia does not rely on any basis to make its allegation according to which an Armenian was allegedly killed, detained, or subjected to an enforced disappearance due to his or her ethnic origin. CERD does not regulate enforced disappearances. They occurred in the context of armed hostilities. In order to define enforced disappearances, Armenia, in fact, relies on the International Convention for the Protection of All Persons from Enforced Disappearance. The reason why Armenia is attempting to bring allegations of enforced disappearances under CERD is clear. Armenia is a party to the International Convention for the Protection of All Persons from Enforced Disappearance, whereas Azerbaijan is not. Armenia's only means to bring its allegations before the court is to try to extend the court's jurisdiction ratione materiae under the SERD beyond acceptable limits. In fact, Armenia is well aware that its claims do not fall under SERD. Indeed, in its memorial, Armenia itself notes that enforced disappearances are prohibited by customary international humanitarian law. At the risk of repeating what has already been said, I would like to recall that this court stated in Ukraine versus Russia that, and I quote, the court lacks jurisdiction to rule on alleged breaches of other obligations under international law, such as those deriving from other international human rights instruments. End of quote. In the absence of specific evidence proving different treatment based on ethnic origin, Armenia's allegations do not implicate SERD. Armenia's attempt to argue that the allegation of disappearances should be, and I quote, viewed in the context of Azerbaijan's incessant hateful rhetoric against ethnic Armenians, unquote, is an attempt to put them within the scope of SERD. But as Mr. Wordsworth pointed out, this is not sufficient to transform allegations related to the conduct of armed activities into allegations that would fall under SERD. Mr. President, members of the court, this concludes my presentation, as well as the first round of Azerbaijan's oral pleadings. I would like to thank you sincerely for your attention, personally, and on behalf of all the members of Azerbaijan's delegation. Thank you, Mr. President.
I thank Mrs. Boisson de Chazourne, whose statement brings this sitting to a close. The oral proceedings in this case will resume at 10 a.m. tomorrow, Tuesday, 16th of April, when Armenia will present its first round of oral argument. The sitting is adjourned.